Thank you, Mr. President. Good morning. I choose to read just two portions of my decision. I'll start with the question of the basic structure and its application to Kenya. The basic structure doctrine prescribes that notwithstanding the absence of explicit limitations on the constitutional amendment power, there are implied constitutional limitations which guard against amendments that change the basic structure or identity of a constitution. A matter that dominated this appeal is whether the doctrine is applicable to the Constitution of Kenya. I've had the advantage of reading the draft judgments of the President of this court and my brother, Justice Kiage, on this highly contested matter, and I'm substantially in agreement with their analyses and conclusions. I propose, however, to weigh in on the proposition that the doctrine should be rejected solely for the reason that had the framers of the Constitution intended this category of limitation to be part of our law, then it should have found explicit expression in the text of the Constitution. Another matter that I shall reflect on is what constitutes the basic structure in our Constitution. The appellates argue that to hold that the basic structure doctrine applies to the Constitution of Kenya is to impose an additional hurdle to an already onerous mechanism for constitutional amendment, it being asserted that the provisions of Chapter 16 are sufficiently onerous and have failed at least 19 attempts to change the Constitution. We were urged to adopt interpretive coordinates to reach an outcome that contradicts express substantive provisions of the Constitution. The clarion call on this side of the divide was that this court should not endorse an extra constitutional mechanism for amending our Constitution. The answer to these arguments, and accepted by my brother Justice Kiage, is that fundamental alterations to the core of the Constitution requires the exercise of primary constituent power of the people, which exists notwithstanding non-codification, and that an insistence that it should be expressly provided by the Constitution is an antithesis of the very concept that it is a power which exists in spite of the Constitution, and to provide for it is superfluous. It is common ground that the interpretation of the Constitution is influenced by both text and context. And in this regard, there is the Supreme Court of India decision in the Reserve Bank versus India versus Peerless General Finance and Investment Company, where the court said interpretation must depend on text and context. They are the basis of interpretation. One may well say that if the text is texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best which makes the textual interpretation match the contextual. A history of the making of the current Constitution gives color to the text of the provisions of Chapter 16 on amendments. After making significant strides towards the making of a new Constitution, the Bomas initiative encountered a legal challenge presented in the Njoya and 6 others versus Attorney General and another. In those proceedings, the applicant inter alia sought a declaration that certain provisions of the Constitution of Kenya Review Act, which was the legal framework for the Bomas process, transferred, diluted and vitiated the constituent power of the people of Kenya to adopt a new constitution. Ringera J, who was in the majority, took the following view, and I have set out his view. You would be familiar with it because it has been quoted extensively by parties here. Then the judge makes this important holding towards the end of his decision. From what I have stated so far, it should be manifestly clear that the bane of the Act is the inherent presumption that the making of a new constitution could be accommodated within the power of Parliament to alter the constitution. As demonstrated herein, the two are entirely different processes requiring the exercise of different powers. The former requires the exercise of people's constituent power, and the latter requires the exercise of Parliament's limited amendment power. The essence of that decision was that the making of a new constitution could only be through the exercise of people's constituent power perfected in a referendum. So as to conform with that decision, the Constitution of Kenya Review Act was amended to provide for a mandatory referendum to ratify a new constitution. All this while, however, Section 47 of the repealed constitution still read that, and I have quoted it, that it was only Parliament which could alter the constitution. I will not read those provisions. As things stood, there was now a mechanism provided by statute for adoption of a new constitution after the exercise of people's constituent power in a referendum, but which mechanism was not contemplated by Section 47 of the repealed constitution. In the run-up to the proposed referendum, the process faced yet another hurdle. In Nairobi Miscellaneous Civil Application number 677, Onyango and 12 others versus Attorney General and 2 others. An issue that arose in those proceedings, and which is not without considerable importance to the matter at hand, was whether a new constitution could validly come into being without an amendment to Section 47 of the existing constitution to provide for the making of a new constitution. In the lengthy submissions before us regarding the doctrine of basic structure and its place, the decision of Onyango and others was not cited at all, and appears to me to be the unsung opinion in the jurisprudence around this question in Kenya. The 3-judge bench of the High Court, consisting of Justices Nyamu, Wendo, and Emukule, observed as follows. However, the exercise of legislative power and the distinction as outlined above is not applicable to the making of a new constitution by a constituent assembly or referendum, because constituent power is not subject to the restraints of any external authority. In other words, the constituent power to frame a constitution is unfettered by any external restrictions and is a plenary law-making power. The power to frame a constitution is a primary power, whereas the power to amend a rigid constitution is a derivative power, since it is derived from the Constitution and is subject to the limitations imposed by the prescribed procedure under the Constitution. And in answer to the very specific question that was posed, whether the constituent power of the people needed to be textualized, the judges were emphatic. And this is what they said. It has been argued that for a valid new constitution to come into being, Section 47 of the existing constitution should be amended to provide for the making of a new constitution. This court does not regard this as good constitutional law or good constitutional justice. First, we have agreed with the holding in Joya that Section 47 does not deal with the making of a new constitution or the process of making a new constitution. The power to make a new constitution was not vested in Parliament. It is the amending power that is vested in Parliament, subject to the special procedures concerning the entrenched provisions and also subject to the doctrine of the basic structure. We must also add that Parliament has no right to alter the basic structure of the Constitution. I'll invite you to look at that decision in extension. 6 days after the Onyango decision, on the 25th of November 2005, the proposed new constitution was put to vote but was rejected by the people in a referendum. Important for the discussion at hand is that there was an attempt to replace the Constitution by the people exercising their constituent power, notwithstanding that the power was not expressly provided by the Constitution sought to be replaced. A recognition, in my view, that the power was not subject to limitations or restrictions prescribed by the written word of the Constitution. A fresh impetus to replace the Constitution came after the post-election violence of 2007-2008. In this renewed initiative, Parliament enacted two cardinal legislations: the Constitution of Kenya Review Act, that is 2008, and the Constitution of Kenya Amendment Act 2008. The latter act then introduced Section 47 of to the then existing Constitution, and so it made provisions on the replacement of the Constitution. I have set out the provisions of Section 47A of the old Constitution. This new section entrenched a mechanism for replacement of the Constitution and expressly provided that the sovereign right to replace the existing Constitution with a new Constitution vested collectively in the people of Kenya and was exercisable by them through a referendum. For the first time, therefore, the constituent power of the people had found itself in the text of the Constitution. Against this backdrop, another referendum was conducted on the 4th of August 2010, giving birth to the Constitution of Kenya 2010. Admittedly, the new Constitution was created in the context where the constituent power of the people to replace their own Constitution had been codified in the Constitution that was to be replaced. What then are the lessons to draw from this journey? First is that the 2005 and 2010 referendums are a testimony that the people of Kenya embraced and adopted a constitutional making concept in which the sovereign right to replace the Constitution vested in the people of Kenya, exercisable through a referendum. The exercise of constituent power in 2005 had received judicial nod in the decisions of Njoya and Onyango, while the 2010 referendum was codified through an amendment to the existing Constitution. The concept is therefore neither alien nor a foreign notion to Kenya. It is very much part of us. Second, and this is the second lesson, the 2005 experience tells us that the constituent power is unfettered and unlimited, notwithstanding that it is not textualized in the Constitution to be replaced. I therefore align to the view that while codifying the constituent power is good constitutional practice, failure to do so neither takes away nor weakens the force of that power. In other words, textualizing it, though a bonus, is superfluous and unnecessary. And this is an invaluable part of the context of the history of our constitution making offers. Let me now turn to the text, because I must compare the text and the context. In doing so, it has to be remembered that, as correctly pointed out by the Attorney General, Njoya was decided against the backdrop of making of a new constitution altogether. Should it be any different in circumstances not involving the replacement of the Constitution, but in regard to its amendment? The respondents to this question invite this court to approach it from the perspective that the basic structure doctrine protects the Constitution against constitutional dismemberment and replacement disguised as amendments. I start by noting that the provisions of Chapter 16 makes reference to the word amendment of the Constitution. Neither in the chapter nor elsewhere in the Constitution is the word amendment defined. And the Interpretation and General Provisions Act, Chapter 2, is not helpful because by dint of Section 2, the provisions of that statute do not apply in or to the construction or interpretation of the Constitution. Turning elsewhere, Black's Law Dictionary, the 10th edition, defines amendment as follows: a formal and usually minor revision or addition proposed, made to a statute, constitution, pleading, order, or other instrument. This can then be contrasted with what a repeal or abrogation is. A repeal is abrogation of an existing law by express legislative act. Express repeal is repeal by specified declaration in a new statute or main motion. Abrogation is the abolition or repeal of a law, custom, institution, and the like. Now, to be inferred from these definitions is that unless otherwise expressed by a constitution itself, an amendment entails a minor revision, alteration, or addition to the Constitution, but which nevertheless does not destroy the Constitution being amended. It does not extend to abrogation, complete repeal, or replacement of the Constitution. In this regard is the work of Richard Albert in his text, Constitutional Amendments, Breaking and Changing Constitution, where he makes a distinction between amendment and dismemberment. He takes a view that constitutional dismemberments are transformative changes with consequences far greater than amendments. They do violence to the existing Constitution, whether by remaking the Constitution's identity, repealing or reworking the fundamental right, or destroying and rebuilding a central structure pillar of the Constitution. A constitutional dismemberment can both enhance or weaken democracy depending on what in the existing Constitution is dismembered. It is incompatible with the existing framework of the Constitution because it seeks to achieve a conflicting purpose. So in truth, the purpose and effect of constitutional dismemberments are the same as to unmake a constitution. So for example, in our context, an amendment to transfer judicial authority from the judiciary and independent tribunals to the executive is to unmake the Constitution, as it fundamentally alters a central feature of the Constitution. An amendment is not as drastic because, properly defined, it keeps the altered Constitution in unison with its pre-change identity, rights, and structure. I then refer to Article 255(1). Now, it does seem to me that the provisions of Article 255(1) simply provide for an amendment, and anything that goes further than an amendment must be sanctioned by the exercise of primary constituent power. The provisions of Article 255(1) and the popular initiative were made against the backdrop that the making and unmaking of the Constitution is a preserve of the people exercising their primary constituent power. A change that derogates from the core character of the Constitution is not a change in unity with the Constitution, but one that defaces it. That change, too, is one that can only be made by the people organized in and exercising their primary constituent power. By falling short of making provisions and procedure for unmaking or repeal or reenactment or abrogation of the Constitution, a textual reading of Article 255(1), in my view, matches or is in accord with the Constitution contextual interpretation of the clause that the people to make such change, that the power to make such change rests elsewhere in the primary constituent power of the people and need not be codified. Let me then turn on what constitutes basic structure of our Constitution. This is what the High Court rendered itself. And I read, while the basic structure cannot be altered I think I'll skip that, but just emphasize that there was a controversy on their finding that whether a particular clause in a constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution. That is what I turn to interrogate. The appellants criticize the findings and argue that the High Court failed to identify the said clauses and provide any objective criteria for such identification. It is submitted that in the absence of clarity, no amendment could be effected without first seeking the court's interpretation, clarification, and concurrence on which provisions are amendable. Thus, therefore, this will be left to the subjective opinions of the individual judges. A common thread running through the Bomas draft constitution, the WACO draft constitution, the revised harmonized draft, and the proposed draft constitution is the provision for amendment of the constitution by popular initiative. The rationale for this amendment process, captured in the final report of the recommendations by the CKRC report, as regards the issue of constitutional supremacy, was that the new constitution should have some entrenched provisions which Parliament would have power to amend without first seeking the views of the people at referendum. Under the scheme of the various constitutional proposals, a distinction was drawn between entrenched and non-entrenched provisions of the Constitution. The entrenched provisions are those that the people felt were the core values and provisions of the Constitution and therefore needed to be barricaded by a special amendment mechanism in which the seal of approval by people exercising their constituent power was mandatory. Notably, the entrenched provisions in the various drafts were substantially the same. In the Bomas draft, they were in respect to the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the principles and values of the Republic, the Bills of Rights, the term of the office of the President, the independence of the judiciary and constitutional commissions, the functions of Parliament, the values and principles of devolution, and the provisions of the amending chapter. The WACO draft retained the same list, save for a small change in regard to the devolution. The entrenched provisions in the latter harmonized draft and the revised harmonized draft are almost forward those in the Bomas and WACO drafts. They again found their way into the protective provisions of Article 255(1) of the 2010 Constitution. It is a list that survived changes made in the various draft constitutions. It is testimony that the people meant what they said and were clear as to what they considered to be the essential features of the Constitution. It is a list to be revered and cannot be shortened or lengthened by judicial interpretation or craft. It matters not that in the mind of a judge, the list is either too limiting or too extensive. To be deduced is that if the people of Kenya felt so strongly that the provisions relating to the matters listed in Clause 255(1) needed protection from indiscriminate amendment, then even more so, those are the very provisions which should not be abrogated or replaced without the exercise of the people's constituent power. In my view, what comprises the basic structure of the Constitution is therefore specifically defined by the people of Kenya, and there are those in Article 255(1) which even in amendment require the exercise of constituent power, and that is the secondary power, constituent power. That said, the true concept of the basic structure in the Kenyan Constitution becomes clearer still by looking more closely at the words of Article 255(1). They require compliance of Article 257 for an amendment that relates to the matters listed in Article 255(1). Save for reference to Chapter 16 and Articles 10, the articles of the Constitution to be protected are not specifically set out. Instead, they are identified by theme. And this makes a difference. What comprises the basic structure is what is in respect to those thematic matters. So, for example, matters on the sovereignty of the people, which power, by dint of Article 3, is delegated to the three distinct arms of government, extends the protection to the doctrine of separation of power. So, while the doctrine of separation of power is not directly mentioned in Article 255(1), it is part of the basic structure of our Constitution, as it is a subset of the wider design on how the Constitution has organized and structured the exercise of sovereign power. I take a view that what comprises the basic structure of our Constitution is therefore easily identifiable. But should a need for judicial inquiry arise as to whether a matter is part of the basic structure of our Constitution, then that inquiry will not be rudderless, neither will it be an unguided exercise, because it is firmly beaconed in Article 255(1). So those are my short views on the question of the basic structure and its breadth. I then turn to the question of the IEBC quorum. In deference to Section 8 of the IEBC Act, the second schedule to the Act makes provisions as to the conduct of the business and affairs of the Commission. The schedule underwent some amendments through Act Number 1 of 2017. In respect to the quorum of the Commission, the amendment reduced it from 5 to 3 in the following words: the quorum for the conduct of the business at the meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3 members. The amendment was not without controversy and was the subject of a constitutional challenge in Katiba Institute and 3 others versus the Attorney General. In a decision rendered on the 6th of April 2018, Muita J declared the new provision unconstitutional. In the impugned judgment, the High Court judges proceed on the assumption that the latter provision requiring a quorum of not less than 5 was the existing provision. The judges do so without ambiguity in paragraph 702 of their decision, which I have set out. The argument by IEBC is that while the decision in Katiba had the effect of declaring the new paragraph 5 of the second schedule unconstitutional, the decision did not revive the older provision, and so, as it now stands, there is no statutory provision on the quorum of the Commission. What would be the legal effect of the above declaration? Cited by IEBC is the decision of the Supreme Court in Mary Wambui versus Gishuki Kingara, in which the court had occasion to consider the effect of a court's declaration of invalidity of a statute or provision within it. I have set out what the Supreme Court said. Clearly, the true effect of such a declaration can only be gleaned from the declaration itself. The court may make the declaration retrospective from the date of enactment of the offending provisions or statute. The court may choose to limit the retrospective effect of such declaration or even to suspend it to a future date. And as held by the Supreme Court in Mary Wambui, whether the effect ought to be retroactive and or proactive depends on a case-to-case basis. So, for example, in petition number 413 of 2016, Boniface Oduor versus the Attorney General, the High Court, after declaring sections 33B1 and 33B2 of the Banking Act to be constitutional, suspended the declaration for 12 months from the date of the decision. Where, however, a declaration by the court is silent as to when it shall take effect, the date of the declaration is deemed to be the date of effect. In Katiba Institute, Justice Muita declared paragraph 5 of the second schedule, amongst other provisions, to be constitutionally invalid without more. The judge neither limited the retrospective effect of the declaration nor suspended it. To be inferred, therefore, is that the declaration operated retrospectively to the date of the enactment of the provision. The repercussion of the declaration was that the amendment of paragraph 5 of the second schedule to the Act, which was introduced by the Elections Laws Amendment Act number 34 of 27, was constitutionally void. Under the Interpretation and General Provisions Act, to amend means to repeal, revoke, rescind, cancel, replace, add to or vary, or the doing of any two or more of those things simultaneously on the same written law or instrument. Amendment of a statute is a legislative act, and while it is open to a court to declare an amendment to be constitutionally void, the declaration does not revive the former provision, just as it does not repeal or annul a provision it has declared to be constitutionally invalid. The former provision would have to be revived by legislation, a preserve of the lawmaking body. And in this regard, I have quoted a Supreme Court decision from India. And although not having a direct bearing to the matter at hand, one would perhaps draw parallels from Section 20 of the Interpretation and General Provisions Act. So, in my view, revival of a previous provision of statute has to be the work of legislative craft and cannot be implied or derived from the judicial pronouncement of the unconstitutionality of the amending provision. And let me explain why I am attracted to this proposition. Take an instance where a declaration of an invalidity of an amendment by the High Court is not challenged on appeal. If it were to be construed that the court's pronouncement amounts to automatically reviving the amended provision, then even courts of a higher rank will be bound by that revival, notwithstanding that such a court would be of a view that the declaration was made per incuriam. This is because the declaration will have removed the amendment from statute. If, however, it is taken that the High Court declaration is simply a pronouncement that the amendment is in conflict with the Constitution and therefore void and inapplicable to the rights of the parties before it, then a court of coordinate or higher jurisdiction is free to arrive at a different decision in another matter because the amendment will still exist in statute. This latter position is perhaps the better position in a jurisdiction like ours, where there is no requirement that every declaration of unconstitutionality of a statute or provision must be tested and affirmed by the apex court. Given my appreciation of the law, I will reach an outcome that although the effect of the decision in Katiba Institute and another was to render the new provisions of paragraph 5 to be ineffective and a nullity, the decision did not revive the former provisions. The argument that the High Court relied on an existing provision of statute is therefore, in my view, with some merit. Yet, as I shall be proposing in due course, in interrogating the question of quorum of IEBC, the trial court was obliged to reach an outcome that was aligned to the expectations of both the Constitution and the IEBC Act. Simply, the court was not handicapped in resolving the matter because the Constitution, read in conjunction with the IEBC Act, provides a clear answer to the question. Next is whether the decision of the High Court in Isaac v. Watt in regard to the issue of quorum was a decision in rem, and if so, whether the High Court was bound by it. The court in Isaac Isaiah Biwott was not called upon to declare the composition of IEBC illegal or unconstitutional as a result of the resignation of 4 of its commissioners, was not only called, let me take that again, the court in Isaiah Biwott was not only called upon to declare that the composition of IEBC was illegal and unconstitutional as a result of the resignation of 4 of its members, but also invited to declare that as composed at that time, IEBC lacked quorum to conduct or carry out the business. You would be familiar with that decision. IEBC is a constitutional commission established under Article 88 of the Constitution. The pronouncement by the court in Isaiah Biwott as to the constitutionality of its composition and quorum was without doubt a pronouncement made in public law and a judgment in rem in regard to the 2 issues. And I identify with the holding in Ems versus Queen that if a formal declaration of invalidity of administrative regulation is not considered effective towards all those who are subject to it, it may mean that to all other persons concerned with the application of the regulation, including subordinate administrative agencies, have to keep on giving effect to what has been declared a nullity. It is obvious, for the purpose of avoiding this undesirable consequence, that in municipal law, the quashing of a bylaw is held to be in rem. I close the quotes. So one would be sympathetic if IEBC were, on the strength of the Isaiah Biwott decision, take comfort as to its quorum. Yet for now, the more decisive issue is whether the pronouncement in rem could bind a court of coordinate jurisdiction. Stated more boldly is the question, is the stare decisis doctrine to be suspended when a judgment is in rem so that the precedent binds a court of equal rank? I do not consider this to be a matter of small importance, not in the least because of the passionate argument by counsel for IEBC that inconsistency of pronouncement of courts in areas of public law confuses members of the public as to what the law is and is a recipe for judicial anarchy and mayhem in public law. Fortunately, other jurisdictions have had to grapple with similar predicament. Faced with the question whether a court was bound to follow the declaration of unconstitutionality of a statute by another court of coordinate jurisdiction, is a view taken by a judge in Canada in the case of R versus Sullivan, which I will invite you to read and which I have quoted. This is what I draw from that decision. The importance of having consistency in the application of the law, particularly in matters touching on the public, cannot be minimized. Both the public and persons or bodies charged with carrying out public functions should be able to tell without difficulty or hesitation whether their actions or conduct passes legal or constitutional muster. To hold that a public body is properly and legally constituted today and to say otherwise the next day may not be good for public administration. So there is much to be gained in legal stability. There is much to be gained in the legal stability that is brought by the stare decisis doctrine. Yet, that has to be put on a scale against the effect of foreclosing another court of coordinate rank from relooking at the same question in a different matter where forceful arguments are made as to the correctness of the earlier decision. Not to allow a revisit would be to stifle judicial debate in an area that may well be unsettled, and in the process to stunt the growth of jurisprudence. It may well be to allow a matter that has been wrongly decided to take root and to perpetuate itself. So as to strike a balance, the doctrine of stare decisis, even in public law, should not apply any different but a latter court should be reluctant to open a matter already pronounced in rem by a court of coordinate jurisdiction unless there is compelling reason to believe that the outcome is different. In addition, I suggest the Attorney General or the public body affected, if not parties, should always be invited to express themselves on the matter before the court renders itself, so that the matter can have the full benefit of arguments on the subject. Lastly, if the earlier decision is on appeal, then the latter court should await the decision, the outcome of the appeal. Let me now return to the circumstances of the decision of Isaiah B. Watt. And this was not challenged, and I have therefore to examine whether the High Court was justified in departing from it. I have set out that IEBC is established by Article 88(1). It is a commission to which Chapter 15 of the Constitution applies. The Constitution does not require enactment of legislation to fix the exact composition of Chapter 15 commissions. However, Article 88 of the Constitution provides as follows in respect to the IEBC. The Commission shall exercise its powers and perform its functions in accordance with this Constitution and national legislation. I would take it that this provision gives national legislation sufficient latitude to fix the number of members of the Commission, as long as it is within the range that is provided in Article 251 of the Constitution, and also to fix its quorum for purposes of effectively discharging its mandate. In its preamble, the IEBC Act declares itself to be an act of Parliament to make provision for the appointment and effective operation of IEBC and for connected purposes. Subsection 1 ordains the Commission shall consist of a chairperson. This is subsection 1 of Section 6, that the Commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution and the provisions of the Act. While the Constitution does not fix the exact composition of IEBC and only provides a range of not less than 3 and not more than 9, statute fixes the composition to be 7. None of the parties suggest that national statute on the composition of IEBC is unconstitutional, and insofar as it does not breach the constitutional range, there will be little merit in an argument that Section 5(1) abridges the Constitution. The statutory composition of IEBC is therefore 7. And as to why Parliament settled on 7, the High Court suggested the Constitution placed the minimum number of the commissioners of the Independent Commission at 3 and the highest number at 9. Parliament, while appreciating the important mandate the IEBC discharges, picked a high number of 7 commissioners to constitute and placed its quorum at 5 members. Close quotes. That is a view I endorse. IEBC gallantly pressed the position that a quorum should be examined against the constitutional contemplation that the composition of the Commission should be 3, could be 3, and if so, the number of commissioners, and if the number of commissioners had fallen to 3, as had at the time material to the petition, then a quorum of 3 met the threshold. I'm afraid I'm unable to agree with the argument by IEBC. Whilst the statute has fixed 7 as the membership of IEBC, it contemplated that death, resignation, or other reasons could cause the actual membership to fall below the statutory number. Given the important constitutional mandate of IEBC, which includes conducting by-elections and referendum, whose timing is unpredictable, the IEBC Act has a robust mechanism for promptly filling of any vacancies. And I've quoted Section 7 of the Act. These provisions speak to the urgency in which the recruitment process must be commenced and completed. Paragraphs 1, 3, and 4 of the first schedule to the statute, which elaborates on the procedure for appointment of the chairperson and members, gives short timelines as a restatement of the speed within which the vacancies must be filled. I have set out those provisions. The scheme of the statute and the regulations is that by providing for prompt mechanism for filling vacancies, then at all times and as much as possible, IEBC should be in its full complement of members. A recognition that given its important constitutional mandate, IEBC should carry out its functions with all hands on deck. To allow the quorum of the Commission to oscillate with the actual number of members at any time would be to countenance a possibility that for as long as the numbers do not fall below 3, then the appointing authority need not promptly or at all trigger the process of filling the vacancies. The membership of IEBC could then suffer want of gender parity or regional or ethnic diversity that is required by Article 254. Drastically reduced membership could lead to a crunch in confidence by members of the public as to the Commission's ability to be independent and truly neutral. The quorum question must therefore be answered against this broader constitution and statutory imperative. And it yields an easy answer, that the quorum of IEBC must be seen against the full composition of 7 required by the IEBC Act. And so I'm aligned with the rationale of the decision of Justice Muita and Katiba Institute. In conclusion, on that question, the effect of the decision was to sustain the quorum at 5 or at least 4. To hold that the quorum could be anything less than half of the membership of 7 is to weaken the Commission. It is common ground that IEBC formulated administrative procedures to guide on the verification of signatures in support of a constitutional amendment, There can be little doubt that formulation of such guidelines will be the business of the Commission, given the critical importance of that threshold in a popular initiative process, and the Commission needed to be quorate. So following a slightly different route, I reached the same decision as the High Court, that IEBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3. So thank you. I'll invite the parties and counsel to read the rest of my decision. Thank you, Mr. President.
Thank you, my brother Justice Tuiyott. The Honorable Justice Zichale will now read another part.
Thank you, Mr. President.